Good afternoon. I hope everyone had a lovely Thanksgiving. Thanks for joining us today to learn about retaliation under Florida's Private Whistleblower Act. I'm Alicia Kepke, your CLE director this year for the Florida Bar Labor and Employment Law section. The course number for today's webinar is 9513. Again, that's 9513. At the bottom of your screen, you should see a Q&A panel. You can put questions into click on that, and then you can put your questions into the Q&A panel, and I will review those as the seminar continues. While we're here, we want to remind you about some upcoming additional CLE opportunities that the section's offering. On December 10th, we will have a webinar on best practices and ethical considerations for FLSA collective actions. That's going to start at 1 p.m. So 1 p.m. as opposed to noon. And then January 15th and 16th at Le Meridian in Tampa, we will have the 26th Annual Labor and Employment Law Update and Certification Review in person. And there's a craft dinner cruise option on the evening of January 15th as part of that CLE section. By the end of the week, you'll receive the materials for this particular webinar that you are attending today. So look for that in your emails. And with that, I will introduce you to our speaker. Cathleen Scott is our speaker today. She is a regular presenter on this topic and others. She's a prior chair of the Florida Bar Labor and Employment Law section. She's board certified, and she was just inducted last month into the College of Labor and Employment Lawyers. Her firm is celebrating 25 years this week, so congratulations to Kathleen. She has held numerous leadership positions, which you can access on her bio that was sent to you with the materials today. And she also has many accolades well received, such as Super Lawyers, AV Preeminent by Martindale Hubble, and Top Lawyer to Watch. With that, I'll turn it over to Kathleen. Thank you.
Thank you so much, Alicia. Welcome everybody to our webinar today. We're going to be talking about everything retaliation under the Private Florida Whistleblower Act. So welcome everybody, and I hope you know how to ask questions, and feel free, Alicia will interrupt and let me know if there's some burning questions. Feel free, we'll keep it interactive if we can. So today, my goal is to focus on kind of three main issues. We're going to go through the whistleblower basics. I hope that everybody will feel like once they've had this meat, nuts and bolts seminar, they'll be able to handle a whistleblower claim from beginning to end. I will try to give you both perspectives. I think it'll be clear which way I lean in towards my bent in favor of employees, but I also represent employers in my practice, so I've made a real conscious effort to try to give some both sides presentation today. Also want to include some real life practical tips, just practical considerations, and we'll do that when it's relevant. And then let's look ahead a little bit at the end, if there's time, some bills that have been proposed but didn't pass last session, which are believed to be hopefully going to be reintroduced, not hopefully, but maybe reintroduced this next session. We'll talk about how those things may affect your practice. So whistleblower statutes, all things exciting in the whistleblower world. Okay, so for those of you who don't know, the Florida Whistleblower Statute is codified at 448-101. It's from 101 to 105. The statutory language is clear, but you're going to find out, as most things in labor and employment law, the statutory language on the page isn't always how the courts have interpreted the language. So it's really important when you're thinking about bringing a whistleblower claim or defending one against your client that you not only read the statute, but take a hard look at the interpretive case law, because there's been a lot of development in the whistleblower statute. So let's dive right in. The whistleblower law prohibits retaliation. And that's like an adverse action that happens to an employee because they've engaged in protected activity. I like to say that retaliation claim has three components: PA, protected activity; AA, adverse action, and those two things have to be connected. So we're going to spend some time going through what is protected activity under the statute, under the case law, and what is an adverse action. We'll talk a little bit about new Supreme Court developments in that area, and then the practicalities of how to prove the causation. Okay, so the whistleblower statute prohibits private employers from retaliating against employees when they engaged in protected activity. Government contractors can be covered both by the private and public acts, but an employer has to have a minimum of 10 or more employees, and there is no individual liability under the whistleblower statute. So compare and contrast that with some other labor and employment statutes that require 15, or the ADEA 20 or more. The employer here has to meet the statutory definition of 10 or more employees. It also means, as a practical matter, some of those employers who fall are too small to be covered under like the Florida Civil Rights Act or Title VII, which require 15 or more, may have claims under whistleblowing. And we can talk about whether that's a good idea or not as we go forward. So who's protected? The statute does not cover independent contractors, and unlike Title VII, doesn't cover applicants. So that's an important distinction. So step one is, in your flow chart of does this person have a claim, start with the basics. One, how big is the employer? Does it have 10 or more? Then check, and then ask the question, is this person truly an employee? Or if they're an independent contractor and they're not misclassified, they may not be covered at all under the statutory scheme. So let's look at, from the plaintiff's perspective, how to count employees, and let's compare that. It's pretty simple. The Florida Civil Rights Act recognizes that kind of the best method is to look at what's called the 941 reports. Those are payroll reports that an employer files quarterly, and those generally can be a great place to look and see what are the number of employees. There can be some outliers. There can be some interesting things to look at there. What about owners? What about board members? What about independent contractors? Can we count those? And the answer is it depends. There's some case law out there that takes a look at that. For example, what if it's a physician's office and there are 9 employees, but there's an owner and maybe there's 4 other independent contractor doctors? Will the whistleblower statute apply? I think you can make the argument that if those other doctors are really working under the control of the employer, there's some case law that supports they might be able to be counted for purposes of the whistleblower statute. So take a look at that if you're making sure, trying to get to that 10 or more number. Let's talk about how to set forth a claim. You heard me say it, and I'll say it again. Retaliation means, do you have protected activity? What's the adverse action? And are those two things related? So the statute lays out its definition of what protected activity is in the statute. And so let's talk about that. There's three different ways, 3 different prongs of the statute, 3 different ways to be engaged in protected activity. The first one is, did the employee disclose or threaten to disclose to a government agency some type of activity, policy, or practice that violates the law? Now, does it have to be in writing? The statute does say that an employee should threaten to disclose in writing and identify what it is that is a violation of law, rule, and regulation. So there's a disclosure obligation here, right? So, and the statute says this provision doesn't apply unless the employee has brought this activity to the attention of a supervisor or somebody who has the ability to correct or cure the situation. The notice requirement in the Florida whistleblower statute, the very first prong, it's unique because it requires 2 things, both that it be in writing and that it require an opportunity to fix the unlawful conduct. And that comes from the Gulf Channel case v. Jenkins. That's a 2000 case. So we need to make sure the employee is meeting both of those elements. The second prong, so prong 1, disclose in writing, give an opportunity to cure. Prong 2 is the employee participating in a government investigation? If so, they don't have to worry about writing. They don't have to worry about the disclosure requirement. If they're engaged in an investigation, then it has to be they're investigating a violation of a law or rule, then that employee might be engaged in protected conduct. The first 2 prongs seem hard because they are, but don't worry, there's the third prong. The third prong of the statute allows sort of like the catch-all phrase. When he is engaged in protected activity by just objecting to or refusing to participate in some type of conduct that's a violation of law, rule, or regulation. For all of those listening who are saying, well, does it have to be an actual violation or a suspected violation? We're going to talk about that in detail, but for now I'm just focusing on the language of the statute. So the statute says if you object to or refuse to participate in something, that could be protected activity. What does that look like? It looks like this. Hey, Kathleen, take this toxic waste out and dump it in the lake behind the office building. I'm not dumping that behind the lake and behind the office building in the lake. That would be an EPA violation. And I get fired for not doing what that's an example of an objection or a refusal. It meets the definition. I don't have to put it in writing. I simply have to prove that I did it. And I have to show that it's a potential violation or regulation. And so if I've done that, then I've done enough. In this context of employment law, it's probably more common to have employees object to things like their wages, how they're being paid, feeling discriminated against. And you could do that in writing and give an opportunity to cure under the first prong, but it's a little easier to meet it under the third prong of the statute. Okay, so we've gone through what generally what protected activity is. So when it says a law, rule, or regulation. So it doesn't mean what it says according to the case law. So what's sort of an interesting development, there's a whole body of law that says a law, rule, or regulation has to be a legislative body or some type of legislative grant of authority, which means if the employee is complaining about a statutory violation or the employee is complaining about an ordinance, it likely could be protected activity. But it does not include complaints, say, about the rules regulating the professional responsibility of the Florida bar. Clear case law on point that says if you complain about something you think is unethical, let's walk through a real example. Paralegal at a law firm reaches out to the managing partner and says, I think that attorney Kathleen is violating the professional rules of conduct because she's doing XYZ. And I get fired and that get fired for making that complaint. Does the employee have a claim? Probably not under this statute because the rules of professional conduct are not deemed to be a type of law, rule, or regulation that qualify as a law, rule, or regulation under the whistleblower statute. For all you guys who are jaw dropping right now, I didn't write the rules. I'm just sharing with you. This is what's happened. There are some other surprising ideas of what isn't a law, rule, or regulation as well. There's some cases talking about refusing to follow an injunction or following an injunction of a court. That also is not considered to be a law, rule, or regulation. I'm not sure how judges might feel about their injunctions and being told that they're not a law, rule, or regulation. They might feel differently, but at least for purposes of this statute, that does not qualify. Complying with or not complying with an evacuation order, also not considered a law, rule, or regulation for protected activity purposes, or a FINRA rule. That one's interesting as well. So it's important. So you've met, let's go going backwards, because I know this is supposed to be more of an entry-level seminar. Does your client have a claim, or what are the defenses to a claim? Let's start. Big picture is how many employees do they have? 10 or more, check. Is it truly an employee or an independent contractor? If it's truly an employee, check. Then we go to the next step. Has the employee engaged in protected activity by doing one of the three things we just mentioned: complaining in writing, disclosing to somebody who has the ability to correct the behavior; two, investigating or participating with a government investigation would be second prong; and then third prong, that catch-all: I've objected to or refused to participate that which I think is a violation or which is a violation of law, rule, or policy. So just to kind of sum up where we are. So what about a policy of the employer, right? The statute does say law, rule, or regulation and references policy. So, but here's something interesting. No, a policy of the employer is not a law, rule, or regulation as that term is defined under this particular statute. What does that mean? If your handbook says that you will do certain things, X, Y, Z, or provide them to an employee, that is not a policy, and you object to that for them not following that, that does not give rise to a whistleblower statute. And the example that I've given in here is, what about an employee who complains about an offer letter or a handbook policy that says, you know, I should be getting 40 days of PTO and I don't? Well, that is not considered to be a law, rule, or violation. So if an employee objects saying, hey, I have 40 hours of accrued time and I'm not permitted to use that because, you know, the end of the year is coming and I haven't had a chance to use it, can I bring a whistleblower claim if I get fired for making that complaint? And the answer is no, probably not. Well, you can, but you might not be successful with it, at least under this statute. So a lot of activity about what is protected activity, whether it has to be just the employee has to think it's a violation of law, or does it have to be an actual violation of law? And so here's where we are with that. It's pretty clear that under the first and second prong, by the language of the statute and the way that's been interpreted in the case law, that yes, under the first and second prongs, it must be an actual violation of law. However, there's been a lot of legal activity under the third prong of the statute. If I object to something, is it enough that me, employee, think it's a violation of law? Or does it have to rise to the level of an actual violation? So we've had some developments. The fourth DCA, which is where I am in Palm Beach County, has said a good faith belief is enough. As long as the employee believes in good faith that what they're complaining about to be a violation of law, rule, or policy, then that's enough for them to engage in protected activity. And that case is the Airy case versus Wallace. It's a 4th DCA 2013 claim. It has been followed by other 4th DCA cases. However, the 2nd DCA has rejected Airy in a case called Kearns, and the 5th DCA has also rejected Airy in a case called DROZD. And the 1st has also rejected that in a case called Gessner. So we have the 4th is kind of the standalone with this, this doctrine that a good faith belief is enough. And the 2nd, the 5th, and the 1st, 2nd, 5th, and 1st all saying no, it has to be an actual violation. Recently, in March, I guess not that recently, but in March of 2025, the Gessner case, which is the 1st DCA, certified the question of whether it has to be an actual violation or a suspected violation. And that has been fully briefed. There was oral arguments happened in October. We're just waiting for a ruling. I checked actually this morning before today's presentation, and as of right now, there is nothing on that point yet. So we will see on that point. So let's drill down. As a practical tip, you want to help an employee complain. You don't want an employee to stick their neck out and complain to HR unless doing so actually elevates their legal position, right? So make sure what the employee is complaining about is actually protected activity. Again, a handbook policy is not going to be enough. Discrimination is enough if it's an actual violation. And also the complaint has to be made in good faith. So bad faith complaints will not be sufficient to set forth a claim. A practical tip is if an employee complains to HR about feeling discriminated against, or maybe saying my wages are less than other males in the same role as me, that could be protected activity. But don't miss this critical distinction on how to kind of the anatomy of a claim. Protected activity is just the first step. Then you have to suffer an adverse action, and then you have to show the two are connected, right? So it's important that if you're making a complaint on behalf of an employee or drafting one, make sure it can be a good idea to include the decision maker or HR on those complaints so that they know you can prove that the decision maker was actually aware that a complaint was being made. Okay, so I think we've kind of exhausted the protected activity first step. So the second thing is adverse action. What is an adverse employment action? And again, this is an exciting area, lots of change happening. In a Supreme Court case, Muldrow, which you've probably heard about in 2024, has said that there is some lower reduced standard as to what an adverse action is. And I see Alicia has joined us back, so I'm wondering if there's been a burning question for protected activity.
A question about what you meant on the prior slide about laws of general applicability.
Yeah, so what that means is we don't know, right? So what the courts have said is that if it's a statute, if you're going to complain about a particular statutory violation, that's probably going to be enough to be a protected activity if you follow the rest of the items. What we know is that judicial rulings like orders and injunctions have not been enough. We also know that when governor issues an executive order, that's kind of like a general rule of applicability. That hasn't been enough to be a protected activity. So I would stay focused on whether or not there's a statutory violation that's being complained about, and that should really be where the investigation needs to be. Thank you so much for the question.
Yeah.
Okay, so getting back to adverse actions, so we know from the U.S. Supreme Court, that the Muldrow case has moved away from a material harm standard into a some harm standard. And so what that means is it's a reduced standard. And so now we have to talk about what that looks like. And so what I thought would be helpful is I put up kind of a list of kind of examples of what an adverse action might be. Traditionally, we would think about the termination. Often clients come to us when they've been fired. So that's usually the one we see, but that's not the only one. And it would be a mistake to only focus on the termination because there could be things that happen prior to the termination that could be an adverse action. And there's good reason to do that because in proving the causation element, we want these things to be close together in time. Close in time from when an employee engaged in protected activity and suffered the first adverse action. So maybe they complained and then they got moved or demoted, or they were denied a transfer, or their schedule was changed, or they found themselves now they're no longer eligible to earn overtime, or they suffer a minor write-up. Those things, if they meet the some harm standard, can all qualify as an adverse employment action. So don't overlook the smaller things that have happened that might lead to the termination, because that can help close that gap between the protected activity and the adverse action. On the employer side, also don't overlook that gap, because that could trigger the statute of limitations running even earlier. Because under the Muldrow standard, it's some harm, but that also triggers the statute to run from the date of the earlier action. So let me hit pause there and see if there are any other questions on those points.
Yes, we have a question that it says regarding the decision maker's knowledge of an objection. Does the Whistleblower Act include cat's paw theory of liability?
So I'm not sure that the cat's paw theory has been directly applied in the whistleblower context. I think you can make an argument that it can, in part because there is case law that says that we analyze claims under the whistleblower statute similar to the way we analyze them under the Florida Civil Rights Act and Title VII. So I think that is a logical extension. On the flip side of that, there's also the manager rule argument, which has been kind of rejected in the Title VII context, but is still applicable in the whistleblower context, at least as of now, and it hasn't been challenged. Manager rule is, I am the HR director. I've complained about discrimination in the workplace and I feel retaliated against. The defense to my whistleblower claim is that, well, hey, I'm the HR director. I should be investigating claims of discrimination. And anyway, that's part of my job. And so it's not really blowing the whistle if it's part of my job duties. And so that is very much alive in the whistleblower context, at least as of this day. So hopefully I've answered. But the cat's paw, to my knowledge, I'm not aware of any direct case. If somebody is, put it in the chat or let us know so we can share. I'm not sure that I've known that, but I think by extension and how similar the statutes are interpreted, I think you could use that body of law as well.
Thank you. And then another question. Has the Muldrow decision been adopted by a court under the Private Whistleblower Act?
Under the whistleblower statute, it applies by the same body of case law we were just discussing earlier. So yeah, what is an adverse action is defined by the Muldrow standard in the Supreme Court, and that's the some harm standard. And that's what we've been talking about. Yeah, I think it is.
All right. And another question, would a hostile environment be quote unquote some harm under Muldrow?
That's a great question. I think it depends on how hostile the environment is, and what that means. I think about the Burlington case, which kind of in a retaliation context talked about what could be retaliatory. And some harm still does mean what it says, meaning it has to be some harm. So if you're sitting in a workplace and people are ignoring you, but it isn't affecting your performance, maybe it isn't. But if you're sitting in a workplace and people are actually like engaging in bullying you, or I had a case once, believe it or not, where somebody was throwing like wadded up pieces of paper at an employee and calling them names, that would obviously affect someone's ability to do their job well. I think that could qualify under the some harm standard. I think it's going to be one of those, not you know it when you see it, but it has to be something more than a slight, right? Because we know that mere slights aren't going to be enough. But if it causes the employee an inability to perform their job or disadvantages them, in Muldrow, the issue was the employee went from being able to wear plain clothes, driving a vehicle, I believe she was a lieutenant, and then being required to wear a uniform and had her car taken away from her. So obviously those are examples of adverse employment actions and that all preceded her separation. So I think in that context, that's what it means. It has to have some harm, and that's likely going to be some harm to the employee. Good question. Okay, so moving right along, we talked a little bit about Muldrow. I think that Muldrow is going to have far-reaching implications on two things. One is, we talked about it, what is an adverse action? We can include more things in there. That's also going to back up the statute of limitations. So from the plaintiff's perspective, be careful about that, right? So maybe the statute isn't running from when you're terminated. It might be running from that when you first got that demotion or started to feel that some harm standard of an adverse action. It also may affect what is relevant evidence. So in pre-Muldrow world, we might be focusing on, only the most extreme adverse actions, the termination, for example. And therefore, we're looking at maybe comparators or people the company didn't terminate for similar conduct. And that's what a comparator is, and that we'd be focused on that. But now that the adverse harm is a little broader, we can expand that scope of that evidence a bit in terms of what is relevant. So maybe we're looking at, the demotion. Maybe we're looking at, being moved to a different location and you don't have access to meetings and things and how other employees have been treated in that context. So I do think there's going to be a bit of a broadening of what could be potential relevant evidence. And so that'll be an interesting to kind of watch, and things that we should be thinking about as practitioners. So as a practical tip, we want to make sure that the decision maker for the employer is aware that the employee engaged in protected activity. This seems obvious, but those of you who practice in the defense can weigh in on this. This is often, these cases come down to it. Did the decision maker know at the time they made the decision to terminate somebody, did they know that that employee was engaging in protected conduct or making complaints or making objections? And so you have a chance, if you represent the employee early enough on the plaintiff side, to tell your client, copy your supervisor, copy HR, make sure that they know, don't leave it to chance. On the employer side, this is a really strong defense, because if you can't show that a decision maker knew about the protected activity, then they can't have animus towards that employee because of their protected conduct, and therefore you may not have a successful claim. Sounds like, do we have another question?
We sure do. Are
Okay.
you able to pursue a cause of action under Title VII and the Florida Private Whistleblower Act, or are you precluded from pursuing a cause of action under the Whistleblower Act if the actions involve discrimination protected by Title VII?
Great question. And so there is no election of remedies requirement under the Florida whistleblower statute right now. But it's such an interesting question that you asked, because the bill that was before the legislature in the Florida legislature last session actually did have an election of remedy requirement in it. That did not pass. So as of right now, no, you can pursue both a whistleblower claim and a Title VII claim. And it's an interesting conversation to have, because it's like, should you do both? Which one's better? Which one, which has more risk? And so if you're making that consideration from the plaintiff's perspective, from the employee's perspective, I might suggest that if given the choice between the two statutes, I would argue that the Title VII Florida Civil Rights Act claim may be less risky for an employee, because as we're going to get to in a moment, the whistleblower statute it's hard, right? You have to show a violation, and maybe even an actual violation, depending on which prong and depending on which way the court goes on that issue. It's also hard because you have to avoid, there's a prevailing party attorney fee provision in the whistleblower statute that's different than in Title VII in the Florida statute 760. And so I think that in analyzing the risk, it may be a less risky claim for your client to bring if they brought the Florida Civil Rights Act claim and the Title VII claim. So appreciate the question. We have an active group. That's great. All right, so here are some other aspects, just to kind of check the box on everything whistleblower statute, since I promised I'd bring that to you today. Here's some interesting things. A case under the whistleblower statute can't be removed if what is being complained about is a federal law, rule, or regulation. So it's an interesting idea to note that it's not necessarily subject to removal based on the subject of the protected activity. The statute of limitations for a whistleblower claim is 2 years, but also allows for up to 4 years based on when you discovered the retaliatory action. This one's a hard one for me to understand, because I don't know how an employee wouldn't know. I guess maybe it was like they were denied a raise and they didn't know, or they were paid less. That could be a possible way. But if you're fired, obviously it's going to run from 2 years from when the termination took place. But if you're not aware of the adverse action, you may get up to 4 years. Okay, so what do you have to plead in your pleadings, and what do you have to prove? So you have to prove under prong 1 and 2, and possibly under 3, you have to prove a specific violation. And what does that mean? Does their client have to be a lawyer? Maybe, because I've had judges require me to put specific statutory citations as to what was being violated in my cases for whistleblowing. So that is something to take a look at. And I'll go ahead and repeat what I said earlier. The courts do apply the same framework for whistleblower statutes as they do in Title VII retaliation claims, which means it is the same. I have to identify my protected activity, my adverse action. Then the burden shifts to the employer. It's a very light burden of production, just to show, no, I engaged in these protected activity. I engaged in this adverse action, not because of whistleblowing, but because we're downsizing, or because you engaged in violations of our company policy. And then the burden shifts back to the employee to establish pretext. So it's the proof and the pleadings and the burden of proof are typically the ping pong match that we're used to in Title VII. You fired me because I blew the whistle. No, I fired you because you were late 3 times in a row and I warned you. And then we have to show, well, other employees weren't fired. That's pretext. So it's that very same analysis. Under the whistleblower claim, you can get a jury trial, and they're commonly asked for, and parties can agree to arbitrate, and those arbitration agreements thus far have been enforceable in this context. So let's talk about damages. And this is something else to kind of factor into when you're thinking about what is the best claim I can bring on behalf of my employee, or what kind of damages can I get if I'm defending the claim. It's important to know. The statute specifically allows for injunctive relief, although I've honestly never seen it happen, to prevent future violations and continuing violations. The statute does allow for reinstatement, which, like Title VII, Florida Civil Rights Act, is generally the preferred remedy, but again, never seen it work in a case that I was personally involved in. The employee can sue for their lost wages and lost benefits, as well as, quote, any other compensable damage allowable at law. There is a statutory basis for, no, there is case law basis for getting emotional distress damages as well. And the attorney's fees provision do exist, but they also are prevailing party. And I want to hit pause on that for just a minute, because even though I've never had a court award damages against a plaintiff or plaintiff's counsel in this context, I do think it's something to consider when you're advising your clients on the risk of bringing a whistleblower claim. Title VII and Florida Civil Rights Act claims don't have prevailing party, they have prevailing plaintiff standards. Also, while a defendant could try to seek attorney's fees and costs, they'd have to meet a pretty high burden to show that a claim is frivolous or wholly without merit. And that's a pretty high burden, right? And generally in the civil rights context, courts are a bit reticent to award attorney's fees and costs because they know these cases are difficult, and courts tend to want plaintiffs to have an avenue to bring these types of claims for public policy reasons. That, what I just explained, is from a case called Christianberg. And so Christianberg really, the case law really frowns on sort of punishing plaintiffs for bringing these types of claims. But compare that to the Florida whistleblower statute that has a prevailing party standard, which literally means what it says. The prevailing party in any claim will be awarded their fees. That means if the defense wins, they have a stronger argument in this context than they would under Title VII and Florida Statute 760 to get their fees. Also, Christianberg has not been applied to the whistleblower statute. So that whole body of law talking about public policy and encouraging plaintiffs to bring these types of claims hasn't been adopted and extended to the whistleblower statute. And then the last thing, and it looks like we have another question, is there's no punitive damages available under the Florida whistleblower statute. So getting back to the question about whether you should bring, or can you bring, a whistleblower claim together with a Title VII or Florida Civil Rights Act claim, maybe you think about that, because we talked about the attorney fees and the risk. Also, the damages aren't as robust. You don't get punitive damages, which is something you can get under the other statutes. Alicia.
All right, so we have a comment as opposed to a question. Kelly Holbrook said that her prior firm handled the Cairns case, and the court initially did award fees to the defendant client before it was reversed. So thanks for
Thank
sharing
you.
that, Kelly. That's interesting context to hear about. And then Jim asked if the materials will be shared. And yes, you'll get an email from Amy from the Florida Bar later this week, if not today, with the materials.
Thank you. And thank you, Kelly. Glad you're chiming in. All right, next top. All right. So some practical considerations are really just what we've been talking about this morning and this afternoon is risk, right? If all things being equal and you have a claim under multiple statutes, the whistleblower one is one you really need to give some thought to, and then ask, what are you gaining by adding it? And so that's an important thing to know. Also, representing a whistleblower has its challenges, like all plaintiffs work and all work in this context, people lose their job. It's so much more than what they do. It's part of who they are. And so when you're representing anybody that's, suffered that type of loss, it can be a challenge and it can be a difficult time for them. But here in this context, I'm talking about the type of person who's a whistleblower. In my experience, have often been people who are up on reading the internet, very much using AI, know a lot of things, crossing a lot of T's, dotting a lot of I's. It can be a little bit of a challenge. So I don't know if anyone has a personal experience they want to share about that. The whistleblowers are a little different, a little bit more intense, I think is the right way to describe it, as compared to the average plaintiff. And then from the employer side, I also wanted to flag what I find to be interesting in representing employers. Sometimes when an employee complains, the knee-jerk response is either to get angry. Sometimes a better employer, a more evolved employer might be like, well, let's investigate. Let's find out if there's any accuracy to this. And so I wanted to share a thought I had, which was by investigating the employee's complaint, are you then actually elevating the employee's position? Because maybe they don't meet the threshold of complaining in writing and complaining about an actual violation, but maybe if they're participating in an investigation, and maybe if during this investigation they continue to oppose various practices of the employer, maybe now you've given them more protected activity than you had intended to by trying to investigate their complaint. So it raises an interesting question about whether an employer making a decision about, do you investigate all complaints that are made, or do we want to be more selective about that, and being cognizant and mindful of the fact that maybe by doing the investigation, you might be raising the and elevating the employee's position a bit. So these are things to keep in mind for your individual cases. Okay, so we're right on track with time. Keep asking those questions if anybody has anything, and feel free to share. But I want to talk about, with the time that we have left, some exciting things that have happened last legislative session. You've heard me kind of shadow it a little bit, but I don't know if we learned last legislative session that the state of Florida can introduce a whole lot of bills, and a whole lot of them can be passed. I think there was over 81 pieces of legislation that was introduced during the Florida session last term. Someone can correct me if that's wrong, but I'm pretty sure that's the right number. And so one of the areas was a potential whistleblower statute change was also introduced. It did not pass. It did not pass. So let me just say what we're talking about right now are things that haven't happened, but seem to be a trend and towards what's coming up down the pike ahead of the time. So the original act that we've been talking about passed in 1995. It was involved a senator, Republican Senator Stan McClain, who initially introduced it as Senate Bill 1776. And the original version of that bill is very different than what the actual whistleblower statute that we know and went through today ended up being like. What we see is sort of an effort to kind of go back to the original bill. And I'm going to go through it in a little bit of detail because I think it's helpful. So the definitions of who an employer is, not a ton of change on that, but let's just look at it. So when we talk about what it means to be engaged in protected activity, this is directly from the proposed legislation itself. And what it means is that unless an employee proved that he or she notified a supervisor or the employer in writing, and there was a reasonable opportunity to correct or cure the actual or proposed violation, there is no protected activity. So that's very similar. So that's not anything super different than what we have today. But this one's a little unique. It uses the phraseology of the employer, which means that it is not protected activity if what the employee is complaining about violates the employer's policy, or if it's contrary to the employer's policy, or if it's outside the course of the scope of employment. And so this one's a little hard to wrap your brain around, because most things, if the employer is violating the law, that's probably not going to be in the course and scope of an employee's workplace, right? In my example with the toxic waste, that's an example of the EPA is being violated. And so that's sort of an interesting question. And so that if that passes, that'll be a pretty large change. The next big change in the proposed legislation was, is there a new standard for pretext? So look at this language. I've underlined it for you. If any employer provides one or more reasons for taking a retaliatory personnel action, other than saying I was whistleblower, then the employee has to prove that each of the reasons is false. And so there really isn't just a general pretext requirement anymore. This is really the actual reason has to be, each and every reason has to be disproven. I'm going to pause there because it sounds like we have another question.
We do. Could you please provide the attendee with the Senate bill number again for this purpose?
Yes.
Thank you.
You bet. And it is 1601 was the House bill, and the Senate one was, I think I said it, 1776. And I can actually send you the bill. If that person wants to email me directly, I'm happy to send them the bill. So continuing on with the new proposed changes in the bill that was introduced last session, the attorney fees was no longer discretionary. It's a shall. The court shall award attorney's fees and costs to the prevailing party in a whistleblower claim. That's a pretty big shift for what I would consider to be kind of a public rights statute. And then a little foreshadowing, we talked about this previously. The last big difference in the current statute compared to the proposed changes is the election of remedies. And so just let this resonate for a minute. The proposed language from the last bill stated that if an employee avails themselves to another statutory remedy, like the Florida Civil Rights Act or Title VII, then they cannot bring a claim under this chapter. So there truly is an election of remedy requirement. So you couldn't bring both claims if this bill were to pass in its form or in some similar form. Which these are very similar items that were in the original whistleblower statute before it passed in 1995 by the same senator who introduced them. So this is interesting, and they all got negotiated out, thank goodness, and we ended up being left with a bill that's a little better. But this one is definitely trying to go back to that past and try to impose some really, really difficult issues with the statute. So just to do a quick sum up, then we can open it up for questions. The remedies that would be available, you can't pick another statute. You're stuck with it. If you go whistleblower, then that's it. So just a quick summary of the changes in the proposed legislation. There's a stricter notice requirement. There's a change that says if what you're complaining about violates the employer's policy, then there is no protected activity. That's a little odd, but it is what's in there. Fees are mandatory, and there's now would be, if this passed, an election of remedy requirement. So a pretty big shift and a pretty big change from where we are now. So I'll definitely keep my eye on this. I do a podcast regularly. It's just the Kathleen Scott podcast, and we talk about this and these changes, and we'll bring them to you as they arise. So at this point, I will turn it over to any questions or comments that people have.
All right, we have another question. Under the current statute, can you comment on a violation by an employer versus a violation by an employee of a law, rule, or regulation?
Good question. So it doesn't matter who's doing the violating. If an employee complains about it and it's related to the workplace, then it's going to be protected activity. So it could be the employer that's violating it. Let's say I'm not paying overtime, and that's a violation. Or it could be that the employee is engaging in some type of violation, and you could report that employee as well. So either one would work as protected activity. Good question. And while we're on the overtime topic, let me also just draw a parallel that if you have an employee or a client who is feeling like they're not paid properly or felt like they spoke out about unpaid overtime or unpaid minimum wage and suffered a retaliation, the overtime statute does have its own whistleblower provision, which is a lot more forgiving than the one we've been going through today, and does not require that written report or that disclosure requirement.
All right, another question. Are building code violations a violation of a law, rule, or regulation?
So I think it would depend on whether the building code violation is a violation of like internal documents, like HOA documents, that type of thing, because I would argue maybe not. But if they did violate a particular statute, then I would think that yes, then that would meet the statutory violation of that. So I know Alicia is she's nodding her head, so I feel better about answering that question with her encouragement. Any other parting thoughts, ideas, questions?
Yep, we've got another one, and please keep them coming. All right, Gary asks, can you define quote unquote related to the workplace? If co-employees are breaking the law, for example, doing drugs at the work site, is that a violation of law by the employer?
So if the sole basis for the liability against the employer was like they're negligent and not stopping the employees from doing drugs in the workplace, I think that's tough because a negligence claim, like a breach of contract claim, those probably aren't enough to be blowing the whistle. But if you could establish that the employer knew or was readily aware that the employees were doing drugs and then did nothing, and the types of drugs they were doing were illegal as opposed to like drinking alcohol, I think you would have a stronger argument on that particular whistleblowing front. So I know that's a bit of an unusual answer, but what I'm trying to think about is what is an actual violation of the law. So drinking alcohol on a premises is not a violation of the law, right? Because if you're over 21, if you're consuming a lawful drug, that may violate the employer's policy, and complaining about that may not be enough as protected activity. Not that I think this, but I think the case law might go this way. But I think if they're doing something illegal, an illegal drug that would violate the law if they were found doing it, that probably would be enough because that would be a criminal offense, and that would likely be a statutory violation of the law. If anyone feels differently about that, I'd love to hear that opinion, because this is not something I've seen a lot of case law on, is when an employee complains about coworkers doing that. I think that's probably a tough claim unless you can prove the knowledge and prove that what they were doing actually violated a statute.
So we had a comment in response to that. One of the attendees said they had a similar case recently, and there is case law saying that drug use is not a violation of a law that is applicable to the employer.
Okay, we got a
Thank you for
group of
chiming
smart
in.
people here. Thank you for that. Yes.
All right, we've got a few additional questions. When would the proposed amendments take effect? And does the proposed election of remedies change mean that you could not seek relief for retaliation under the Whistleblower Act and Sarbanes-Oxley?
So these statutes are not in effect at all. What I read to you was the bill that was proposed and passed the House last session, but did not get any further, but has been promised to be reintroduced by that senator. So I think we can expect that this is going to be reintroduced. In ordinary course, I would say a bill like this probably wouldn't have a shot at being, introduced. But given what happened with the Choice Act last year and how quickly everything got passed, I think we should be aware as practitioners and keep an eye on this. So that section of the presentation is for your knowledge to keep your eye looking ahead. It is none of those have been passed yet, but I think we can expect that they're going to be reintroduced in the next session.
All right,
What was
next
that?
question.
There was a second part of that question too, I think, about Sarbanes-Oxley. So
Yep, that's right. Yeah, does a proposed election of remedies mean that you couldn't seek relief under the Whistleblower Act and the Sarbanes-Oxley Act?
it would mean, yeah, that's what it would mean. But I think the way that would go down is you could bring your Sarbanes claim, and if you added the whistleblower case, then there'd be a motion to dismiss the whistleblower claim, and your Sarbanes claim, would likely continue on.
All right. If the employee reports unauthorized conduct that the employee knows the employer would not allow, would that still be considered a violation of law by the employer?
I don't know, because you're using the unauthorized conduct, so we really need to move away from that to be engaged in protected activity. We need to take that language and really apply it to what is this conduct? Is unauthorized conduct sexual harassment? In which case, yes, that would be protected activity. Is unauthorized conduct bullying behavior? I think that's a harder one, even though there is an OSHA regulation on bullying, so you could maybe try that. But I don't know that unauthorized behavior is going to be enough to get the job done. You really want to be able to say this conduct violates this statute, and then complain about that in order to have that kind of, to the extent there are any slam dunks. That's really what you need, I think, to have a clear whistleblower violation. These things that fall into the gray area of like behavior that might be immoral or negative or unauthorized. I don't know what that means, but if it means just general workplace, people being bad to one another, that's complaining about that. It might expose your client to the risk of being terminated without elevating their legal position enough to have a claim for retaliation. And so I might steer them away from that. And I might look at other statutes for relief, like while we have it, the National Labor Relations Act might be a better source of relief for your client to complain about. And remember, this presentation is only focused on whistleblowing. So it doesn't mean that complaining about unauthorized behavior might not fall under other statutes like concerted protected activity under the National Labor Relations Act. But for pure whistleblowing, I don't know that that's going to be enough without a violation.
All right,
It's a
James.
sad day. It's a hard day to be a whistleblower. We should all appreciate those people who've stuck their necks out and who brought us those claims and done those things.
James included a comment, but it was from a couple minutes ago, so I think it's a little out of order now. He said, I believe it would have to rise to the level of a policy or practice of the employer.
Right.
And we are all caught up. So any final questions before we close out for the day? I'll give it just another minute. No, looks like we're good. Kathleen, thank you so much. This was a very informative presentation. As a reminder for everyone, the course number is 95113, and you will receive a copy of Kathleen's PowerPoint presentation, possibly later today, but by the end of the week for certain. As a reminder, our next webinar is December 10th at 1 p.m., not noon, 1 p.m. That's going to be on best practices and ethical considerations for FLSA collective actions. And then we hope you'll join us January 15th and 16th in person in Tampa at Le Meridien Hotel downtown for the 26th annual labor and employment law update and certification review. Thank you so much, Kathleen. Thanks
Thank
to all
you.
of
Good to
our
be here.
attendees. We hope to see you on December 10th. And you can click right there to register for the January 15th and 16th in-person certification update. Hope to see you there.
And I think you have my presentation, right? Are we still on?
I believe we are still recording.